Well, here we are in the Capstone again, and last time we were here, we were making some comments on the court's jurisdiction, personal jurisdiction, subject matter jurisdiction, venues, some areas like that. Just real quickly, want to remind you quickly of that. Remember that the laws, generally speaking, are organic, meaning they come out of the Constitution, and then they go basically into the various different parts of statutes, rules, and then what we call common law cases or case law. Remember about, we talked about subject matter jurisdiction, saying that some courts have limited jurisdiction, others have general jurisdiction, and thirdly there is appellate jurisdiction. You can also have concurrent jurisdiction, meaning two courts could both hear this case, or exclusive jurisdiction, which involves just one court and only one is the right court for this certain case. Personal jurisdiction, remember we talked about the requirement for minimum contacts. Okay, so there's a difference between federal and state courts too. Always keep that in mind. Keep in mind too that there can be bars to litigation. This involves statutes of limitations, res judicata, which is kind of equivalent of double jeopardy. Has this case been heard before? If it's already been decided once in the civil court system, you cannot bring a new original lawsuit along those lines. Immunity, sovereign immunity, some states demand that, but generally speaking with the 14th Amendment, equal protection and due process and these kind of things, people have certain civil rights, and so some of that is wearing down over the years. Basically keep in mind there's a lot of different remedies involved here. There's legal remedies, which is damages, money damages. You can also have equitable remedies, which involve, basically what it even sounds like is a recognition of that there is equity involved. May not fit neatly inside of one of these laws, but basic fairness and justice require that we carve out some kind of an equitable remedy. Last thing we want to touch on this before we move on to a different topic in Chapter 8 is that we have alternative dispute resolution. And in alternative dispute resolution, that's where we try to negotiate agreements using mediation, or it is possible to have what we call arbitration. And both of those have come into the forefront. Generally speaking, mediation is a lot more popular. Well, let's move on now to Chapter 8 and look at some of these points real quick. Important points, and again, this is the Capstone Certified Legal Assistant Prep Course. Remember that there is a fourth branch of government, and that's what we call the administrative law branch. I just shorten it to admin law. Admin law. So this is about admin law. Okay. Now the concept of admin law really did not take a hold until about 1930, and then during that time they could see that there was so much growth in the government, partly brought on by the Depression, partly just the times, life was becoming much more complex, and it was expensive, time consuming to try to go to court, so they're trying to resolve things. Now this in administrative law oftentimes involves different branches of the government. So they don't necessarily work for the court system. They can work for the executive, which is to say the governor or the president. And so what they do is they develop kind of a hybrid approach to problem solving. And this, like I've said before, you can see it in Social Security, you can see it in workers' compensation, you can see it in a lot of administrative agencies. The EPA, it just goes on and on and on. Even atomic energy, there's a lot of, they have regulations, they have regulatory boards, they also have what they call administrative judges. that work within the system. You still do have the right to appeal to the standard court system, but you have to go through these administrative remedies first before you can even qualify to go to court in some of these cases. So basically, there are some executive type administrative legal functions. There are some legislative administrative functions. Just the way our system is set up, they always end up, in terms of from an appellate standpoint, in the judicial system, but they may not start out there. There are issues like subpoenas, Congress, city councils, the governor, different people have the right to issue subpoenas, not just the courts. There are also certain kind of search warrants that can be obtained, like for example, welfare of children, things like that. You can get a warrant, basically a court order to go in and look around somebody's home, where you wouldn't be looking for marijuana or anything like that. You're just looking, are these kids clean? Is the house clean? Is it full of bugs, mice, trash laying around everywhere? I mean, folks, I've been in places working in the government where there's just like dog poop everywhere within the house. You got little kids running through it. I mean, it's just disgusting. You'll have pizza that's been sitting on the coffee table for a month, you know, full of crud. You know, you can see all kind of things. Been places where they've got dishes stacked almost all the way to the ceiling. You know, they never wash anything. They go in and see the bathtub full of dirty clothes, never wash any, don't wash themselves, don't wash the clothes. It's just amazing sometimes. So these investigations go into different areas like that, like the welfare of children. Safety, is the wiring safe in this house? Is this house need to be condemned? So you get court orders, special administrative court orders, just for that from administrative agencies. Basically, administrative laws, I said it's developed in recent years, since the 30s. It is coming up. One of the big things in here, there is a due process requirement in everything that we do, but some rules, like the hearsay rule, are relaxed. So it's important you know, that we understand that there are certain nuances in administrative law, and because some of the rules are relaxed, people get upset when someone comes in. They may bring in a letter, let's say for a doctor, to a Social Security hearing. The doctor wrote a letter, said, yeah, this lady's really sick. I don't see how she can ever work again. Well, I mean, that's legal in administrative law. You don't have to have a formal deposition of that doctor. So, same thing, you know, applies to some of the other rules of evidence. Standard of proof is the more relaxed standard, preponderance type standard. And there is review of this. It can be heard up the line, and actually can end right up in the Supreme Court, just like other types of proceedings. Well, okay, spend some time on this. I know it's kind of new to you. Be sure, though, to you know, familiarize yourself with it. A lot of it is very similar, if not the same, as what you've heard before, except some of those special things, like I pointed out about the rules like the hearsay rule and some things like that, where certain types of evidence are allowed, like letters and stuff, and you don't have to have the live person come in and testify, where they can be cross-examined. So these are just things that you want to consider as you look at this whole thing on administrative law. Well, I hope you enjoyed these couple of short lectures that I've given you. Want to encourage you to keep up the good fight. Don't give up. There's a lot of work in this course, I understand it, but the whole point of it is to help you get prepared to get that certificate. So it kind of puts you head and shoulders above some other people that claim to have some certain capabilities, whereas you've proven it by qualifying for this test and then taking the test. So thanks for persevering. Hang in there. Let me know if I can help you. Always, robdawalt@me.com. Thank you.